Now that Morgan Stanley is leaving the protocol, what are the implications for financial advisors? Attorney Joel Beck joins me to share his insights.
This is the Resilient Advisor Podcast, the show for high-performing financial advisors. We bring you the best practices of the industry's top performers so that you can build resilience in your business and your personal life.
Thanks for downloading this episode of the Resilient Advisor Podcast. My name is Jay Coulter. This topic is incredibly timely at this time, and Joel Beck was the first attorney I thought of to bring on the podcast for you to discuss the implications. Joel is the founder of the Beck Law Firm and an expert on issues financial advisors face. Joel, let's get right to it. What are the implications of this decision?
Well, I think it's yet to be determined, but what we do know is that the advisors at Morgan Stanley now are not going to be able to rely on the protocol for broker recruiting if they're looking to make a transition and go elsewhere. That's what we know now. What we don't know yet is how this is going to play out and whether there are going to be other wirehouses that follow suit and pull out of the protocol as well.
So I like to start with the positive. What are the positives for current Morgan Stanley advisors, especially the ones that really didn't have the idea that they wanted to leave the firm?
Sure. Well, I think there may be some positives there. When you look at the firm's press release announcing what they're doing, it seems that they're going to have a real initiative, a real push to focus on growing and developing their current staff, including their financial advisors. And my sense is that if they're now freeing up these resources that they were using in recruiting producers from other firms, they're now going to have some more resources to invest in their current sales force.
Yeah, that makes sense. And, that's something that the Morgan Stanley advisors have been asking for a long time. And it looks like they're going to push those resources there. What does this mean to recruits that were considering Morgan Stanley?
Well, I think they're going to take a pause and a big breath and evaluate a possible transition in light of this move. They would have to know going into a transition to Morgan Stanley that the firm would no longer be a protocol member. And if it doesn't work out for whatever reason, and that advisor then wants to go somewhere else, then they may be subject to some restrictive covenants based under contract with the firm. And that could significantly hamper their career as well as hinder their ability to make an easy move out to another firm that might be a better fit.
So what if you're an advisor at a competitive firm and you're looking at a firm that isn't Morgan Stanley to make a move to? There has to be some reservations. Is Merrill Lynch, is UBS, are they looking at the same type of process? How would you advise that advisor to approach looking at other firms other than Morgan Stanley at this time?
Well, I think they've got to be cautious and they want to have some discussions with management at the prospective firm that they're considering. We don't know if other firms are going to follow Morgan's lead and withdraw from the protocol. I think that some firms are going to stay in and perhaps tout that they're staying in and maybe use that as a competitive advantage in recruiting, stating that they're pro-advisor and pro-client. But for those that are considering going, to another firm, they're certainly going to want to discuss, with recruiters and management, well, where does the firm seem to be going with respect to the protocol? And if there are some concerns that the firm's not going to be a good fit and we need to go somewhere else or, possibly down the road, or they want to preserve that opportunity, then the advisor might need to get pretty aggressive in negotiating the contract and making sure that the advisor does not sign a registered rep agreement that contains restrictive covenants that's going to hinder him or her from being able to make a smooth transition.
Yeah, that's interesting, Joel. We've already seen some of their competitors, or one in particular, Raymond James, put out messaging about how they are going to remain advisor-focused and still stay in the protocol system. So you're right. I could see exactly how their competitors might use it against them. How the devil's obviously in the details. How can advisors make sure that they're covered?
Well, what they're going to want to do, I think, is work with their practice coach, you, for example, as well as work with experienced counsel who works with financial advisors. The devil is in the details in these registered rep agreements, and they have to be especially cautious as to any restrictive covenants. And what I mean by that is language that has a covenant not to compete or a covenant not to solicit or not to hire. These types of covenants under contract law can be enforced, and it can really hamper an advisor if they want to make another move following signing this particular contract. Now, of course, the enforceability of these restrictive covenants are going to vary based upon state law, and you've got to look at which state's law would apply. But the bottom line is advisors have to understand that words have meaning, and these contractual provisions can be enforced in many circumstances. And so they don't want to agree to give up certain rights that they don't need to or that aren't good for them and their career.
The devil is in the details. Joel, I appreciate you coming on short notice to talk about this important, timely issue. If somebody wanted to get in touch with you, how could they find you?
Sure. They can find us online at thebeckfirm.com or give us a call at 678-344-5342.
I'll have that information in the show notes. Joel, thanks for coming on.
You bet. Thanks, Jay. Keep it up.